Okay, I'm showing 9 o'clock, so I'm going to begin the session. People can join as we proceed. Good morning. Welcome to today's webinar. My name is Jim Danhauser. I'm a volunteer with the Cape Cod and Islands chapter of SCORE. I wanted to cover just a couple of introductory items before turning things over to our facilitators for today's discussion, Kyle Pardo and Terry Cook of AIM HR Solutions. AIM is a Boston-based company that provides a full slate of HR consulting services and trainings to Massachusetts businesses of all sizes. And we're very fortunate that these two senior executives from that company have agreed to lead today's discussion. You see listed on this slide the organizations that provide assistance to us in presenting this webinar. We're supported by the Cape Cod Chamber of Commerce and the various chambers of commerce located in towns throughout Cape Cod and on the islands, as well as by the Community Development Partnership in Eastham. And as always, we're very grateful to these organizations for their ongoing support of our educational efforts. For those of you who are not familiar with the SCORE, we're a resource partner of the U.S. Small Business Administration and a fully volunteer nonprofit organization. Our mission is to foster vibrant small business communities through mentoring and education. We've been pursuing this work since our founding in 1964 through educational opportunities like this webinar and by providing mentoring assistance to people who are in business or who are thinking about starting a business. At our Cape Cod and Islands chapter, we benefit from having over 50 volunteer mentors and subject matter experts, people with a broad array of varying business experience and expertise, all of whom stand ready to provide mentoring assistance to you. And the same holds true for all of the other chapters in our Massachusetts Rhode Island district. And we can connect you with volunteers throughout the country to make sure that people with the appropriate experience for your area of question are available to you. So if you'd like to take advantage of this mentoring, all of which is completely free and absolutely confidential, there are a couple of ways that you could proceed. One, you could go to the website for SCORE National, which is www.score.org. Click on the Request a Mentor tab from the drop-down menu under the Find a Mentor tab, enter your zip code, and proceed. Or you could go to the website of the chapter that covers your geographic area that are listed here and click on the Find a Mentor tab to get started. Next slide is our last preliminary, I promise. Today's procedures, all participants other than Kyle and Terry and myself have been muted. I ask that you enter any questions into the Q&A feature using the button that you should see at the bottom of your screen. I will be watching that and posing questions as they come in to Kyle and Terry, so it's easier for me to do that by looking just at one feature as opposed to having to toggle back and forth. And Kyle and Terry have fashioned today's discussion to leave ample time for Q&A, so we will be sure to get to all of your questions. Webinar is being recorded. I will send a link to the recording to everybody who registered for the program sometime in the next day or two as soon as it's available. And we will launch a short poll just before the end of the program. I would ask you to respond to that before you leave. It simply helps us to make sure that our educational programming is addressing the needs of our small business community. And now I'll turn things over to our facilitators for today, Kyle and Terry. So Kyle and Terry, take it away.
Great, excellent. Thank you so much. I'm going to go ahead and share my screen here as we get started. Everybody able to see that? We're in? Okay, excellent. Good. Well, thank you again, Jim, for having us here today. We have, again, put this presentation together to really focus on what is needed for human resources for your businesses, thinking about those small to mid-sized companies. We know that you are spending a lot of your time and effort on running your business, doing the things that you enjoy most. And we want to make human resources part of it, which is a big part of it, but we want to make it as simple as possible to help you kind of create a checklist for yourself of what needs to be done. And, you know, as we go through the presentation, we do welcome your questions. We're happy to stop and at any point and answer those questions. So we thought it would be good to start with really what's required. What are the basics that every company must have? And number one are employment posters. These are, required by every single company, regardless of your size. And employment posters communicate essential information about labor laws, workplace safety, employee rights, things like that. And we'll talk about each of these items a little bit further in depth in just a moment. The second basic requirement is the Form I-9. You may be familiar with this. I hope you're familiar with this, but this is the form that is required for every single employee to show that they're eligible to work in the United States. And so regardless of your company size, you are required to be having every employee complete the Form I-9. And there's a new form that just became effective November 1st. And so again, I'll talk about this more in a moment. Number 3 is personnel files. So having a file folder, or perhaps it might be electronic, but keeping a personnel file for every single person who works for your company. And that's where you're going to keep all the important information regarding their employment. And then the fourth item I put on here is job applications. Job applications are technically not required, but there are a lot of good reasons to have them. So we'll dig into that a bit further. All right, so let's talk about those employment posters. Employment posters, again, they provide an overview of all of the employment laws. So things like minimum wage, work hours, child labor laws, Americans with Disabilities Act. These are all the types of laws that your employees need to be aware of and to know that you as an employer are following those laws. So these need to be hung in a place in your place of business that is available to all of your employees. So you could hang them in a break room. You might want to hang them if you have a time clock. You could put these right near the time clock because you know when people will see that. You could put them outside of kind of the main office area, but certainly they need to be hung somewhere where employees can see them on a regular basis. The posters themselves, the information that's included in these posters, there are a couple of different ways to get posters. You can get them for free. You can go onto the Department of Labor website. You can go onto the Massachusetts Department of Labor website, and you can download these posters for free. You could put them in kind of those plastic paper protector sleeves and hang them up on a bulletin board. So that would be the free option. I really don't recommend it for a couple of reasons. The main one being is that they're regularly updates to the posters. And if you are doing it yourself, downloading them for free from the government websites, you would really need to be going back regularly to those sites to make sure you have the most updated versions. The second reason why I don't recommend it is because there are different posters that apply to different size organizations. And again, you as an employer would have to kind of dig through some of that information to make sure you had the right posters up. What is on this slide here is you can see that there are several different updates that have happened to these different laws just within the past year, within 2023. And so these are the types of things you would have to be staying on top of. So what I do recommend is you can order the posters very often through your payroll company. If your payroll company doesn't have them available, you can purchase them online. I would just do a Google search for employment law posters, but there are a couple of companies I've used in the past. One is G Neil, so the initial G and then NEIL. Another one that I've used is JJ Keller, but there are many vendors out there. And when you purchase the posters through a vendor, they're going to send you that laminated poster, and they're also going to likely sign you up for a subscription where if there is a change in one of these laws, you will automatically get updated posters. The other good thing is when you go through one of these services through a payroll company or one of these vendors is you can typically tell them how many employees you have, and they're going to send you a poster that's targeted based on the size employer you are. And later in our presentation, Terry will get into the different laws that apply based on the size of company. So step number one, if you don't have them, would be to make sure you have employment posters. And again, this easiest way is probably to order those online. Number two, the Form I-9. So the Form I-9, again, there's a brand new form that just came out. It came out in August, but it really became effective November 1st. So you would want to look at the bottom of the form if you're already using one and look at the effective date. And if you have anything that's earlier than August 1st of 2023, you should know that there is a more current form that needs to be used. So you can go do a search online for the Form I-9 and you can find the new form. This form must be completed for all employees within the first 3 days of employment. And what you're going to include on this form are things like the basic information, the employee's name and address, social security number, things like that. And then you're also going to be gathering documents, and there's a very specific list of documents on the form itself, but forms that show that this person is eligible to work in the United States. So it might be something like their passport is one option, or there are other options where it might be a combination. So it might be something like a social security card and a driver's license. So you want to pay attention to the information that is on that form to make sure you're documenting it correctly. So when an employee starts, you would have them fill out a portion of the form. You would look at their documents to make sure that they are accurate, that it looks like a real driver's license to you or whatever documents that they're presenting. You're going to write down the information on the form. And again, this must be completed within the first 3 days. So if a new employee says to you, oh, I don't have it, I can't find it, it's at my house, it's somewhere else, whatever, they would not be able to continue working after 3 days. You would really need to make sure you have that information. You are able to get a photocopy of those documents, but if you do that, you need to either keep photocopies of the documents for everybody or for nobody. We recommend that you do keep those photocopies and keep them with that form, but you can't just kind of pick and choose who you do it for. You need to do it for all or none. And this Form I-9 then would get stored in a file that is separate from the employee's personnel file. So a separate file that is just for the Form I-9s. And the reason is if you were ever audited, you would have all that information together. But because it contains a lot of personal information, again, it includes name, birth date, social security number, things like that. This must be stored in a locked file that only you as a business owner or somebody in the very senior management team has access to. So really make sure that that is kept in a very secure location.
Kyle, a question
Yes.
had come in. Do you have to have I-9 forms redone as the form changes, or if somebody signed the older version, is that sufficient?
Good question. No, you do not have to redo it if the form is changed. The only time you would need to do an update is if somebody had a temporary form of documentation. So it might be that somebody has a work visa or something that expires like that. And that information is really specific on the form and will tell you. So if somebody had a work visa that was expiring, you'd want to have a tickler system to let yourself, to remind yourself to ask them for an updated work visa. So you do not need, otherwise you need to do a form. The other thing I should have said too is that these forms need to be kept throughout the duration of a person's employment with you. They need to be maintained. This is a little bit tricky, so I'm going to try to say it really slowly. They need to be kept for at least 3 years from their date of termination. 3 years from their date of hire, or 1 year from the date of termination, whichever is longer. Okay, so if you only have somebody work with you for the summer, for example, you only have somebody work with you 3 months, you're not going to only keep their document for 1 year after their termination date. You're going to keep it for 3 years at least from their hire date. Okay, so if you have if for any of your employees, you need to keep them for at least as long as they're employed. Okay, plus an additional 1 year after that. But if somebody's only works with you for a very short period of time, keep in mind it must be at least 3 years from that date of hire.
Kyle, just a quick note, because I know you talked about visas expiring, et cetera. So sometimes we get questions about whether somebody's driver's license expired or something like that. So that's not something you have to re-verify. The only time you have to re-verify a document is if it's related to their authorization to work in the United States on your I-9.
Really good point. Thanks, Terry. Okay, Jim, any other questions on the Form I-9?
No, there's a question on workers' comp, but we'll get to that when we get to workers' comp. Perfect.
Okay. So personnel files. you should maintain a personnel file for everybody who works in your company. And this is where you're going to store all of those important documents that have anything to do with their employment relationship with you. So the types of information you're going to put in the personnel file are things like their employment application, their offer letter that says when their start date was, what their higher salary was, a resume, if they happen to have given you a resume, any sign-off forms like a sexual harassment policy or other types of forms like that that you have them sign off on. If you do any performance evaluations, if you have any warnings that you give them for any behavior in the workplace, emergency contact information, and then any other types of agreements or certificates. So this is all going to go in the personnel file. And think about this as the place that if the employee came to ask you for a copy of their file, they would have access to everything that is in this file. Okay. If a supervisor, if you have a big enough company where you have different levels of management, if they asked to see the personnel file, you could certainly have a policy of deciding who on your supervisory team would have access, but I would not give them the file. You know, I'd have the supervisor come to your office. They could look at something. Maybe there's a performance evaluation that they needed, but other than that, I would not give them or hand out the file. This is to be maintained probably by one person in your organization, again, under lock and key, kept in a very secure location, because again, it has a lot of personal information in it. There may be additional documents that you have that should go into a separate type of personnel file. And that's going to be more confidential types of information. It could be something like, perhaps you offer employee benefits and you might have health insurance enrollment forms or beneficiary forms or, something of that nature. You may want to keep those in a separate file so that those would not go if a supervisor needed to look at a file, for example. You could keep those separately. Let's see what else you have. Reference checks. If you have done reference checks on an employee, you would not put those in the personnel file because those would not be shared back with the employee. Those would be kept separately. Okay, so again, thinking about your main personnel file is information that you would share back with the employee. And in Massachusetts, there are very specific rules about personnel files. If you have an employee that asks to see a copy of their file, you would need to be able to present it to them within 5 days. If they wanted a photocopy of it, again, same thing, you'd have to make that available for them to have a photocopy of. But you can do this in a very secure way. So you're not just giving up the file, but you're doing it all under kind of within your office to make sure that nothing changes in that file. Okay. If you're putting a warning in an employee file, maybe there's a behavior issue or something like that, you would need to let the employee know that is going within 10 days, that is going into their file. So you can't just put things in an employee file like that without them knowing about it. Okay. And we're going to jump over to the last of those kind of initial 4 requirements. And the last of those is the job application. And I said originally that this is not required. So many times you may have people who submit a resume for a job, and a resume is great. A resume lists all sorts of good information about what the employee's work history is, but a job application is really a specific document that the applicant signs on the bottom. So they're verifying that the information they have shared with you is accurate. It also outlines very specifically what you're asking for. So on an application, you're asking them for their work history. You're asking for them to give you dates of hire, dates that they left a company. You're asking them to provide volunteer information. Maybe they've had a volunteer job. And there's also very specific language that should be included on a job application that has to do with privacy and data protection, that has to do with criminal history. And so again, if you were going to use a job application, I wouldn't just create one. I would order one online. AIM has them available on our website in our store, but I would make sure you purchase an actual up-to-date, legally compliant job application. And again, this job application would go into that employee file. You do need to keep job applications. So for anybody you hire, I would put the job application into that employee file. For anybody that you do not hire, if it's a job that you posted, that you opened up for applicants, you need to keep those applications for at least a year. If people just apply and you didn't have any job open, but they just filled out an application and dropped it off, or they just did it somewhere else online, maybe, there's no requirement to keep those. But if it's a posted position, you do need to keep those for at least a year. And again, for employees, I would keep it in their employee file, at least for the duration of their employment. So before we get into kind of all the different laws and how they apply based on the size of your organization, again, I will pause there to see if anybody has any other questions at this point.
No, as I said, the only other question we've gotten so far is about workers' comp.
Okay.
And the question is it the same wherever you purchase it?
Terry, you can jump in on this with me, but so workers' comp is required for employers of all sizes. There are some differences in the workers' comp rate that you're going to get, which is going to be based off of your payroll, the amount of your payroll, your location, your industry. You know, if you're in a high risk industry, it's going to be higher than higher rates than a lower risk industry. What your claim history is. So between insurers, there may be some differences. The biggest thing I would say in terms of looking for a workers' comp insurer would be really, it's a relationship you want to form with them, because you know, you're going to be sharing information with them. You're going to be trying to get people back to work. You're going to be communicating information about, you know, what a workers' comp situation might be. So through your process of looking for a workers' comp carrier, really consider how well they respond to your inquiries. You know, what does their claim system look like, and what do you feel like that long-term relationship might be? And we're certainly happy to connect you. We have some partners in the workers' comp space, and we'll be happy to connect you as a resource if that's helpful to you. Terry, do you have anything to add to that?
No, I think you've covered it. I do think the relationship is important, but I do think you made some good points about where the pricing could be different depending on industry. You always want to make sure that you have your company, or you're giving the correct code for your company so that the workers' comp company knows what they're quoting. So I think all of that makes complete sense.
Excellent. Well, let's turn it over to you, Terry, then, to jump into the next slides. I will advance them for you if you want to.
Sure.
Just let me know when you're ready.
All right, great. So as Kyle mentioned, we are going to talk about some of the laws that relate to your companies based on the number of employees that you have. A lot of times when a company is smaller in size, it's hard to realize which laws may apply to you. So we won't have time to dig deep into each of these laws, but we're happy to talk to you separately if you have additional questions. Usually when we talk about the employment laws, that course is about 2 hours long, and nobody wants to listen to that for 2 hours probably this morning from me. So we'll just do a nice brief overview for you, and again, available for questions. So Kyle, if you want to go to the next slide. So we're going to start very basic. So if you have one or more employees, so there are some laws that do apply to you. Child labor laws. So I don't know if anybody on the call ever tries to employ people that might be under the age of 18. If you do, there are child labor laws you need to follow in the state. One very basic piece of that information is they have to have a work permit to work for you. So they usually can get that either in their town or at their schools, but they are not allowed to come in and work for you without a work permit if they're under 18 years of age. The other piece is there are a lot of limitations related to the number of hours they can work and what they can do. I'll just give you a really quick example of something that I learned very early in my HR career, and that was we had somebody that brought their son in to do some work in the summer. He happened to be 16 years old, and they thought, well, let's have him do some painting, and then we'll have him do some yard work. Well, we found out quickly that somebody under 18 cannot operate a lawnmower for your company because that's considered machinery. So again, things can be, something that you may not think ahead of time about, but there are some very specific rules about what somebody under 18 can do in your company. So we're happy to get you more information on detail if you do employ people under the age of 18. But those child labor laws do affect any company with one or more employees. Criminal offender record information called CORI. That law does also affect you if you have one or more employees, and that's when you're looking into the criminal background of one of your potential applicants. There is a CORI website that will let you do those checks. They will let you run those checks. You just have to register, go through some of their online training so that you understand what you're reading. So those are essentially background checks and criminal record checks, and there's going to be some rules associated with that that you'll learn about on that site, and also will include having a policy about your background checks and query checks. Fair Labor Standards Act, that is another really important law. Some of you may have been reading a lot recently about the Fair Labor Standards Act because there is a lot going on right now when it comes to the minimum wage requirement for somebody that's going to be exempt or salaried in your organization. So that's one way. It also regulates some of your basic pieces, such as your minimum wage that you have to pay people, that you do have to provide overtime to people that are working over 40 hours in a week. So those pieces are all managed at that. The Massachusetts minimum wage is $15 per hour right now. Tipped employees have a little bit of a less rate at $6.75 an hour, but there has to be a tip credit to make up the difference. So to get to that $15 an hour. So I'm not sure if we have anybody that has tipped employees. Some of those questions can get a little confusing. If you have any of those, you certainly can let us know. As I mentioned, what's in the media recently on FLSA is the exempt, non-exempt. So that really just means whether somebody is salary or hourly. Under the FLSA, it's really important to know that you can't make that decision on your own that you want everybody to be salaried. There are specific tests and rules that have to be passed in order for somebody to be exempt from overtime. So all of those areas fall under the Fair Labor Standards Act. And again, applicable to all companies with one or more employees. The next,
Terry,
Yes,
we
go
did
ahead.
get one question.
Sure.
Do founders need to pay themselves minimum wage?
I think that there's rules. I can look that up for you, Jim, but I think there are rules associated with people as far as how they've established the company as their founder and what they're getting in return for that. So I can take
Okay.
a look at that, or Kyle, you can take a peek for that while I'm moving forward. Happy to look that up for you. OSHA, Occupational Safety and Health, requires a workplace to be free from any safety or health hazards. Anybody that has actually 10 or more employees has to have a log, an OSHA log, but OSHA in general, keeping your workers safe is applicable to anybody with one or more employees. But again, as you move into a little bit larger number, if you have 10 or more, you have to keep an OSHA log of all your injuries and illnesses in the workplace. Probably one of the most recent laws that has passed that's affecting employers with one or more employees and sometimes can get very confusing is the Massachusetts Paid Family Medical Leave. So for those of you that haven't heard of that before, hopefully you have, but essentially companies have to select between state or private plans, but your employees are eligible for paid family medical leave for certain reasons. So they can have a total of up to 26 weeks of pay based on the type of the reason that they're out. So, you know, some reasons that are qualifying, of course, are there somebody's own health condition that they're trying to deal with. That's up to 20 weeks. And again, that would be based on what the doctors are putting in too. It's not just them asking you or telling you. They have to go through an application system with either the state or your private insurer company to get determined about how much they'll be paid and how long they'll be paid. Certainly can care for a family member that might be going through a serious health condition up to 12 weeks. Bonding with your child in the first 12 months is also eligible for up to 12 weeks. And then caring for a family member that's injured in the armed forces, that is where they would get up to 26 weeks. And then there's a last category about managing affairs when a family member is on active duty, and somebody can take up to 12 weeks for that. So this is not a situation where it's only for people that have been with your company for a long time. Some of you that might be a little larger in size may be familiar with the Family and Medical Leave Act, and that's an unpaid leave, and that would be for people that have been with your company for a year or longer. This particular leave is eligible to all employees. They just have had to work for 4 quarters prior, whether that be with you or another employer. So again, it's not a minimum amount of time they have to be with your company. So that's very important and very confusing often. I would say on our AIM HR helpline, that's probably the most common topic that we have. So it's one of those things that, again, people do get often confused, but people should know that once you are registered with the state or a private insurer for your mass paid family leave, what you need to do is you have to have your posters up, you have to provide information to your employees about it, including annually, you just have to give them an update on any rate changes. But in general, once somebody mentions to you they need to take that time away, you really have to just provide the information to the state or your private insurer plan in order to be able to let them start the process. Then you are out of the process until it starts coming to you for verification. So you don't have to go with the employee every step of that way. You just have to wait until it comes back to your attention. So anyway, so that is a little bit about the mass paid family leave. Again, that can be a very difficult topic because there's a lot of people that are trying to deal with all of these situations with employees, and often when you're a smaller employer, I get a lot of questions on the helpline. It can be difficult because you have to allow this time off, and you often don't have other people doing that same exact job, so it can be very difficult. So
Terry, a couple of questions.
of course,
First, that law applies to companies that have one employee. Is there a
Yes.
minimum number of employees, or is it the first employee that applies?
yeah, this is one or more.
Okay.
Mhm.
And then do these requirements apply to employees who reside in other states than Massachusetts? I assume this is a question for a Massachusetts business that has employees elsewhere.
Okay, yeah, it depends on if they're state or federal rules. So as far as the Massachusetts paid family medical leave, those are typically Massachusetts employees. However, it's important to remember that if you have an employee that lives someplace else, but they're working for you and paying taxes in Massachusetts, unemployment in Massachusetts, they're considered a Massachusetts employee.
No matter
However,
where they're based.
that's right. So, but if you have a facility, like a separate location completely in another state, and they're set up for that state for taxes, unemployment, and all of that, then they're not going to follow the Massachusetts paid family leave. They would follow the rules associated with the state that they're in. But when you're looking at things like the Fair Labor Standards Act and OSHA, those are federal laws.
Okay. We had now a follow-up question. Does it apply to Massachusetts employees whose business is in New York and Fenton? I'm not quite sure what that question means. If the I think what Terry just said is that if the employee is based elsewhere, but is working as a Massachusetts employee, that is, you don't have a facility somewhere else, but then they're going to be considered Massachusetts employees.
Yeah, and it really does, what really matters is where you're saying that person is an employee of. So if this person had a facility in New York and they're completely set up in a separate location in New York, then their company's located there, the employee's located there, the company is making sure that they're paying New York taxes, the employee pays New York taxes, the company is paying into New York unemployment. If they're doing all of those things, then that would be a separate state. However, if they're treating that person as a Massachusetts employee in all of those areas, as far as I understand it, they're considered a Mass employee for that.
Okay, so we did get some clarification. It's
Okay.
the business is based in New York, but the employee works in Massachusetts.
Yeah,
So
I think
go ahead, Kyle.
No, I was just to say, I think it's what Terry says, really, where is the employee paying taxes into? They're where they paying their employment taxes and unemployment insurance.
That's
And I
right.
think that will help you decide where is that person,
Yeah,
is-
and if you're taking money from them to pay towards Massachusetts paid family leave, then they would be eligible for Massachusetts paid family leave. But if your business and everything else is treated completely separate, everything's in New York, nothing to do with the Massachusetts, and they're not paying into a mass leave, the only problem that happens sometimes with people that look at this and say, oh, good, I don't have to do anything with Mass. You have to do something with New York. So, you know, I don't know off the top of my head what the laws are in New York for leave, but you have to realize that, you know, if you're treating an employee as an employee of another state, you have to know those state laws too. So if there's a state leave law related to New York, you would have to make sure you're recognizing that for New York. But again, it's really a matter of where they're being, as far as I'm aware, it's where you're paying into and treating them as an employee.
Then we had one other question, which I assume
Sure.
is going to be actually a pretty complicated answer.
Sure.
For salary, what conditions need to be met to be exempt from overtime?
Yeah, that is a little bit more complex. I mean, the minimum salary, if somebody's asking like a minimum salary, right now that's up in the air. Right now it's pretty basic. It's only $684 a week, which only comes out to a little over $35,000 a year. It's proposed to go up to $55,000 a year, but that is definitely not the only way you determine salary. So if somebody makes more than $35,000 a year, that does not make them a salary employee. They do have to meet other exemption tests. There's several on the Fair Labor Standards Act website. They're administrative, there's an executive, there's a professional, there's computer employees. There's a section that describes outside salespeople. So when you're looking at your tests for an employee becoming exempt, the very minimum requirement is the amount of the salary, but that's only the one small piece of determining if somebody can be a salary employee. They do have to meet the other tests. A lot of people tend to look at more at the administrative exemption, and it's important to realize that when you're looking at administrative exemption, that people are making significant business decisions. So a lot of people they'll say, well, I trust this person, they're making they'll make a decision, but if they can't make a decision completely on their own without another approval level, typically they won't pass that exemption test. So again, there's a fact sheet on the DOL FLSA website. So just able to get more information to you afterwards if that's helpful. So that's, I know that we could probably talk all day about a lot of these because they're very confusing laws, but I know in the interest of time, we want to probably move to the next slide, Kyle. So 2 or more employees, and these are both Massachusetts state laws. So this is the Equal Pay Act and the Mini COBRA. So the Equal Pay Act is really making sure that people are paid equally when they're doing comparable work. So really trying to avoid discrimination. People may have seen this back, it's been about 5 years now since it's passed. A lot of it came up due to gender differences where men and women were being paid different rates for comparable work. So that is the Equal Pay Act. As far as an overview, the Mass Mini COBRA is for companies that have 2 to 19 employees. So the regular COBRA rules apply to people with 20 or more. Mass Mini COBRA is 2 to 19. And what that means is when somebody terminates from your employment or follows another qualifying event, they're eligible to continue their insurance. You are able to charge them up to 102% of the amount of that health insurance. The 2% is considered an administrative fee for you having to file everything and keep them with the insurance company. Companies usually will charge at least the 100% of the cost. So that is only your health insurance when you're 2 to 19 employees. You don't have to do dental or vision, just health insurance continuation. Kyle, we'll go ahead and move on to the next slide. 6 or more employees, sexual harassment law in Massachusetts. If you have 6 or more employees, you have to follow sexual harassment law, of course, making sure you have a written policy that talks about having a workplace free of any type of harassment. There is a sample policy on the Mass Commission Against Discrimination website. So that's an MCAD is the abbreviation for that. So you're able to download that, but you do have to distribute that policy annually. You do not have to provide sexual harassment training yet by law. It's helpful if you do train your employees and your supervisor on harassment awareness, but you do have to distribute sexual harassment policy annually. And then the fair employment practices, that is all related to discrimination. You have to keep your facility or companies free of discrimination for your employees. So that covers things such as race and color, religious creed, sexual orientation, age, marital status, handicap, mental illness, military status, gender identity, genetics. The list is fairly long for what you have to protect your employees against for any type of discrimination. And then the Massachusetts parental leave is different than the Massachusetts paid family leave. The Massachusetts parental leave is an unpaid leave, and that is where both men and women are eligible to take unpaid leave up to 8 weeks for the birth or adoption of a child. So again, this would be an unpaid leave, and it can run at the same time as your mass paid family leave, so it's not in addition to. Kyle. 11 or more employees, Massachusetts earns sick time, again, state law. Massachusetts, you have to be able to provide sick time to your employees up to 40 hours in a year. For those companies that have under 10 or under, that can be unpaid sick time, but anybody over that, so 11 or more, has to be paid sick time. And the mass sick time law, you have to accrue time at 1 hour for every 30 hours worked, up to a maximum of 40 hours a year. And all of your employees are eligible for this sick time. It doesn't matter if they're temporary or seasonal, as long as they're on your payroll, part-time, full-time, they all have to earn sick time up to 40 hours a year, 1 hour for every 30 hours work. So it does cap off at 40. Move forward, Kyle. All right, and then for 15 or more employees, these are federal laws as far as the Americans with Disability Act. Again, that's a protection of disability as well, and you would have to provide reasonable accommodations if requested. So that's something we could do a whole session on, but really when an employee comes to you and says they have a disability and they need an accommodation for you to provide, you would have to look at that under the Americans with Disabilities Act. And then the Civil Rights Act is also in place and actually established the Equal Employment Opportunity Commission. So all of these are protections for your employees for any type of discrimination. Want to move forward? Okay. And then go ahead,
We
Jim.
had one question, I'm sorry, about the
please.
Massachusetts earned sick time.
Okay.
How does that apply to your employees that are union? And do they also earn that time? I guess in over and above whatever their collective bargaining agreement provides.
Yeah, they would have to look at their collective bargaining agreement. The real basics is they would get at least the 40 hours. So usually a union contract might try to be a little bit more generous potentially. So they'd actually have to be at least the 40 hours a year. But generally speaking, you just would follow your union contract as long as it's 40 hours or more for sick time. Okay. So 20 or more employees, age discrimination in the workplace. Age discrimination is for anybody that's over 40 or over. So that is a protection that starts certainly at 20 or more employees. So you'd have to take that into consideration when you're making any type of a decision, because somebody can sue you for age discrimination if they're 40 or over and they feel like you're giving benefits to people that might be younger than they are, as far as assignment of shifts or layoffs or terminations. We already talked about COBRA a little bit. That is when somebody terminates or has a qualifying event, you have to continue their health insurance, at least offering it to them at that 100% or 102%. The difference when you have 20 or more employees is you do have to offer them their dental insurance and vision insurance. So that's the difference between mini COBRA and COBRA. And then the mass personnel record keeping, Kyle already did a really good job of going over a lot about the personnel files, but there are different amounts of time you have to keep a lot of your files. For example, payroll records you have to keep for 7 years, whereas a regular employee file might be 3 years. Your OSHA records you have to keep for 30 years. So there's a lot of record keeping requirements that happen for people that have 20 or more employees. And then again, we've already talked pretty extensively about all of their personnel files and things that are in there. Again, Kyle mentioned, make sure you're keeping your medical information separately, make sure you're keeping your I-9 separately. But there are record keeping rules that you must follow when you have 20 or more employees. And we'll end at the 50 or more employees in case anybody might have that or you're getting close to that. We already talked a little bit about the Family Medical Leave Act. That is one for 50 or more employees. And again, that's an unpaid leave. That's not paid, and family medical leave is federal, where Massachusetts paid family leave is state. So that is with somebody that has been with your company for at least 1 year or more. And then there's other pieces that we're happy to go through if you're at that point. Massachusetts domestic violence, again, state leave, where somebody gets 15 days of job protected leave a year if they're in a situation of domestic violence. And then the Massachusetts Small Necessities Leave Act is for 24 hours of unpaid time a year to have people participate in school activities with their children, take them to medical appointments. So that's another one at 50. And then the last one I'll say very, very briefly is under the Affordable Care Act. When you have 50 or more employees, you do have a different definition of what's considered full-time to offer health insurance, and that's a 30-hour work week. So I know we went through all of this very quickly, and this can be very confusing, but I just wanted to at least give you some highlights of the different laws that are affecting you at different levels of employment status in your organizations. Kyle?
Thank you for the breakdown, Terry. I hope we haven't scared anybody away, but hopefully if you can look at it just based off of how many employees you have, it'll simplify it a bit in terms of what applies to you. But questions we get regularly are about employee handbooks. So do you need an employee handbook? When do you need one? What do you put in an employee handbook? My basic guidance is that when you reach 10 employees, you should consider having an employee handbook. It can be very simple. Think about the laws we just outlined on the previous slides that apply to that size company. You might want to include things like the Americans with Disabilities Act, equal employment opportunity, at-will employment, and then maybe some things like your company dress code or your pay day or your work hours or basic benefits or things like that. But at about 10 employees, you can consider a pretty simple type of handbook. And this just outlines what is expected in your organization. Certainly, when you get to 20 employees, 25 employees, you should definitely have an employee handbook. It just captures all of that information in one place and makes it easy for your employees to reference when they have a question. We do provide a model handbook at AIM. It's a good starting place, so we can certainly connect you with that if you don't have one and you're looking for an easy way to get started on a handbook. All right, job descriptions. We also get questions about job descriptions. Job descriptions are technically not required, but they are great for a lot of reasons. They help you with your recruiting to outline what's required for a job. Performance management, when you're evaluating an employee and trying to decide, do they meet the requirements? Have they done a good job or not? You can always look back at the job description. Workers' comp, if you're trying to return somebody to work, you want to know, are they able to do the job? If you have an applicant with a disability and you want to look at the job description, see, could they do that job with or without an accommodation? Pay equity. So comparing comparable positions in your organization is much easier if you have a job description. And then just in general, workforce planning, what is your structure? Who's doing what? How is your work divided? So job descriptions, again, very useful, but not required. So, but I do recommend them. And then the last slide is really an important one. We saved it till the end, but we regularly have questions about a final paycheck. And in Massachusetts, there is a state law that if an employee is terminated, so involuntarily terminated, you must pay them all final wages owed on their last day of work. So if you are going to fire somebody today, you will need to calculate how much they are owed for all of their work done through today, plus any vacation time that they may have accrued. And you would have to give them a paycheck today to hand to them as they're heading out the door. And I can understand that could be a challenge, right? That's difficult, even if you're a small organization. So there are a couple of ways to manage that. And one of the ways is you can call your payroll company. You can say, we're terminating this employee. Here are the hours, here are the wages. Very often they can calculate that for you so that the correct amount of taxes come out and you can cut a company check but then have it recorded into payroll, because you do want that to make sure that's included in wages. But you could do that. Some companies might say, okay, we want to terminate this employee. We're going to terminate them today. We're going to have them leave the premises. We don't need them here any longer, but we're going to have their termination date be tomorrow. It's going to be Friday. And that just gives us a little extra time to prepare that check and give it to them. But that might mean that you're paying them an extra day as well. So you're paying them maybe an extra day to not do any work, but that gives you that extra time. If an employee voluntarily quits, if they tell you they found a new job or they're leaving, this requirement does not apply. So you can go ahead and pay them on their next regularly scheduled pay date. The reason why this is very important to know is because if you have an employee that you terminate today and you don't pay them their final wages today as they are owed, you could be responsible for treble damages. So triple the amount that you would have owed them, you may owe them up in back pay. So just keep that in mind. I know this can happen. You have an employee that does something and it moves along very quickly, but plan on doing that. So Jim, I'm going to open it up to any final questions, and I'm going to leave it on a screen in the meantime that just identifies some training programs that we have coming up that might be helpful. And these are all available on our website. And so if anybody wants to learn more, going to aimhrsolutions.com will get you there. But Jim, any questions that have come up?
Yes, somebody asked, how can I get a sample of the employee handbook that was talked about?
If anybody wants to reach out to me, I can send you the table of contents, so I can share, what types of policies are included in that, and I'd be happy to circulate that.
Okay. I don't know that people have your contact information.
I don't think they do. I'm going to put up a slide here. This is our Director of Business Development's contact information, so anybody can reach out to Kelly, and Kelly can kind of triage it and send it the right way. But at the same time, I'm going to put my email address also in the chat.
And everybody will be getting from me the link to the recording in an email. So you will have my email address there. And if you have any further follow-up questions and would like to send them to me, you can do that. And I'll make sure that we get that information shared with Kyle and Terry.
Excellent.
We have another question. If we have an unlimited paid time off policy, what needs to be paid upon termination? Do we need to pay the 40 hours sick paid time? Do we need to track sick time?
So sick time is not, does not have to be paid at termination. The only time that has to be paid at termination is vacation time that's accrued and unused according to your company policy. So sick time does not have to be paid for the purposes of unlimited paid time off. Usually you have to be pretty careful. We have some attorneys that have been in our human resources roundtables, and they will advise specific wording in your policy as far as what needs to be paid out at termination. So I would certainly recommend taking a look at that to make sure that you're not stuck with any specific amount. If you do the wording correctly, then typically there's not a lot due, because you don't call it, I'm trying to remember what the attorney told us, but if you use a certain label towards that time off that might be considered unlimited, it's really something that's only available when you're at the company. But again, it has to be worded the right way in a policy in order to avoid having confusion at time of termination.
So it's well worth your talking to your legal advisor to make sure that you end up using the right language for that.
Yeah, I think that's really important when it comes to the being able to offer something that's more unlimited basis, and just important in general for your vacation policies to have something specific about what is paid out at termination if you want to do it on what's been accrued versus giving them the full vacation allotment for the year. If you're silent on that and people just know they get 3 weeks a year and you don't have anything that talks about what you pay out at termination, you would owe them 3 weeks even on January 10th, for example, if they think they have 3 weeks for 2024. So you definitely want to take a look at that with your policies.
What is the website to get the salary exemptions / requirements?
I'll put that in the chat, Jim. Let me just
Okay.
pull it up real quick.
It's a
And
really
then-
helpful website. It's under the Department of Labor, but there's a like a questionnaire that you can go through where it will ask you questions about the position. And as you answer these yes/no questions, it will help guide you in direction of whether it's potentially exempt or not. But it's really kind of thinking about, I'm going to use kind of language in quotes, does a position make decisions on matters of significance? So, as Terry said, it's not just that salary piece, the duties piece and what level of decision making the person has is really important in deciding whether a position is exempt or not. And if you're on the fence at all, go non-exempt, make the position non-exempt, pay the overtime, because you'll cover yourself better if you so don't make the position exempt unless you really know for a fact that it should be exempt.
So is it correct to describe the salary level as just the minimum test?
Yes,
Two
That
parts
is-
to it. Yeah, the salary
Yeah.
test and a duties test. So
So
they
you
have
need
pass
to meet the
both.
salaries test, but that's not sufficient.
No, you
Right.
must pass both.
But
Exactly.
it is a necessary element. That is to say
It
that no matter what the duties, if they're below the salary level, then they are not required to be considered.
That's right.
Cut. Okay.
Yeah.
Are there fees for your upcoming training sessions? I believe those are described at your website.
Yes, so good question. So there are fees, and another reason why we would love to connect with you is that there are grants available in Massachusetts, workforce training grants, that if you are an employer with less than 100 employees, you have access to $20,000 of training money as long as you are paying into the unemployment system in Massachusetts, and you can get a certificate of good standing. So it's a fabulous program. The application process is maybe about a 15-minute application. It's called the Express Grant, and we can certainly talk you through how the Express Grant works. Send us an email, send Kelly an email that's on the screen, and you can use that to pay up to $3,000 per course and up to $20,000 for your company per year. So we strongly recommend that you utilize that as a small employer, get $20,000 of free training.
The thing that people need to be aware of is that works as a reimbursement. So you will have to pay the money out and then you get the reimbursement.
Absolutely.
But it's not, you're not getting reimbursed after 6 months. It's relatively prompt.
It's typically about a 30-day period. So yeah, it's not too long.
Great. Any last questions from anybody? Well, Kyle and Terry, I've seen a whole bunch of thank yous in the chat. Everybody felt it was a great presentation, and I concur with that judgment. Thanks very much for your time. As I said, I will send out to people the link to the recording, and this has been just great. So thanks everybody for your attention, and Kyle and Terry, a special thanks to you guys.
Thank you very much for having us. Have a great day.
Mhm.
Thanks.
Take
Bye.
care. Bye.